Any mention?
Please, Your Lordship. Lordship, I beg to make a urgent listing for tomorrow for one matter, my Lord. This is a premature transfer, my Lord, where I am the commandant of 67 Battalion. CRPF, my Lord. I am the CRP. And to it, my Lord, there was an anonymous complaint made by a junior officer alleging I have misused my power. Then later on, my Lord, after that, a preliminary inquiry has been set up, fact-finding inquiry. While that is still pending, my Lord, inquiry, they have issued me, I have been served with a transfer order, my Lord. Then pending to that, my Lord, yes.
Yeah.
Obliged, my Lord.
May it please, Your Lordship. Lordship, I beg to mention item number 14.
Number?
14.
And for the petitioner, Lordship.
Lordship, I prayed for 2 weeks' time.
Why?
Due to some difficulties, Your Lordship.
What difficulty?
Personal difficulties, Your Lordship.
How many months you practice now? 1 year complete?
6 months, Your Lordship.
How much?
6 months.
6 months. Okay, yes. 23 months.
Highly obliged, Your Lordship.
May I please, Your Lordship, I beg to make a mention part of the hearing this item number 11, 12, 16, 17 is a connected matter. If
why?
Some personal difficulties today, Your Lordship.
You don't matter many times.
If this matter may be contempt listed after 2 weeks, Your Lordship.
Why? You have to have some cogent reason for adjourning, not adjourning for the sake of adjourning it.
Counsel, this AG, he's having some personal difficulties. So.
Again, these matters have been adjourned. I mean, can you count the times it's been adjourned? How many times adjourned? At UAPS, at their BS, 125 times maybe. Okay, after 1 week.
After 2 weeks.
You do it after 1 week, give you enough time to prepare.
Your Lordship, please 2 weeks after 2 weeks, Your Lordship.
After 1 week. Okay. Enough. These matters appear again adjourning.
May I please, Your Lordship, item number 20, my Lord. Today I am not ready, so it may be come after 2 weeks.
Yes?
No objection, Your Lordship.
Yes?
No, sir.
Lordship, I beg mention for item 27, Your Lordship. Weeks time will be given, Your Lordship. 27.
What's the matter about?
It's freezing of account, Your Lordship. Freezing of account, Your Lordship.
No urgency?
No, Your Lordship. Mrs. Tapai is not ready today, Your Lordship.
Mr.?
Mr. Tapai, Lordship, is leading in this matter.
Who, Mr.?
Mrs. Tapai, Lordship.
How much? 4 weeks? 4 weeks. After 4 weeks.
Respondent.
You asked for 4 weeks or 2 weeks?
2 weeks for.
Pledge.
Lordship, item numbers 25 and 26, Lordship. Like to mention for 2 weeks, Lordship.
No objection, Your Lordship.
Why?
Because
Lordship, the Learned Advocate General is leading this matter. He is unavailable today.
25, 26?
Yes, Lordship.
this is VC matter, Lordship. There is no stay in this case.
You have interim order?
Interim is there.
Yes, Lordship.
Yeah. 3
Highly
weeks.
2 weeks, Lordship, because
Take 3 weeks.
2 weeks, Lordship. Because AG has instructed for 2 weeks. 2 weeks, Lordship.
Lordship, the interim order may continue, Lordship. Interim order may continue.
Must.
Highly obliged.
Item number 1.
Yes, Mr.
My Lord, here, terminating the cancellation order, challenging the cancellation order of the post of warrant of
cancellation order
dated 13th February 2024, my Lord.
Yes, Dr. Mosika.
I'll file affidavit.
Where's the impugn order?
My lord, impugn order is at page 26, my lord.
You have to refund money also.
My lord.
You're refunded.
Refunded, my
You've
lord.
been discharged. You join a new post.
No, my lord. That's the crux.
But you refunded the money.
I had to, my lord.
What remains now?
My lord, it is the case, my lord. I was a rifleman cook. I was serving there. I got a opportunity. I applied for the warrant officer RM, my lord. Radio mechanic, my lord. I have been persuading them. I have been selected, my lord. Thereafter, persuading the department to give me the NOC to join the post. They have not, my lord. The 9th December, they say that you approach the DGR, the letter is there, my lord, for your discharge and thereafter, my lord. Without, there was intercommunication between the commanding officer and the Assam Rifle Training Center, my lord. The discharge application, in spite of discharge, my lord, they have not allowed me to. I approached the ARTC and
So can you still join the warrant officer now? It's still open.
Open, my lord.
Yes, heard Mr. Yes, Mr. Arja, led the consul petitioner. You notice Dr. N. Mosika, led SGI, so is present. On behalf of all the respondents, no further notice required. List after 2 weeks for instructions affidavit done.
Highly obliged.
You'll get instruction because the matter seems to be urgent. If he's
Item number 2.
You're not there, Dr. Mosika.
Oh, sorry.
My lord, Leonard.
My lord, I was supposed to present the resolution. My lord, as per information of the Rangvashnang, my lord, at that point of time, NOC was issued after discussion with the office bearers, but there was no written resolution, my lord. That was informed by the headman, my lord. That information is there. There is no.
You destroyed that portion of the record. That can only mean that.
My lord, I have been informed this much. I have to submit, my lord, that there was, as per the information, my lord, that a first NOC was issued on the basis of the discussions made with the office bearers, but there was no resolution. Second one was cancelled, my lord, on the basis of the objections raised at the time of year-ending festival, which was conducted in the village.
That's not recorded.
That one is recorded. That is on the record. The second one, my lord, when objections came from the local people.
Let's see the one where the objection, that resolution. Can this court accept this kind of submission, Mr. Nath? Now, if it doesn't suit you that that part of the record says it doesn't exist.
My lord, it is. I have been informed like this only.
No, I'm not blaming you. I'm saying, can it be like this?
There should have been a written official document must have been there.
The proceeding, the record there that the NOC is granted without any proceedings.
There is no.
Let's see that where they resolved to cancel.
Well,
you flagged it.
This is in page 14, my lord, of the affidavit in your petition.
Let's see the original records. Is the original records?
No, not original, my lord.
Well, we asked you to produce original records.
Original is not brought, my lord.
See, you read the order dated 6/8/2025. Okay, that you're allowed to produce the minutes of proceedings or the bar when decisions taken to grant NOC, correct?
My lord.
Now, you must be having, you don't have minutes with you.
My lord, original I have not brought, my lord. I was not well also for a few days, my lord. That's what I couldn't. I'll produce this tomorrow, my lord.
You produce the proceeding of the bar.
Tomorrow, my lord.
Yes, concerning the entire matter.
Yes, my lord.
Mr. HMR today has submitted that there are no recorded proceedings with regard to the resolution. There's no recorded proceedings.
Yes, my lord.
Wherein deliberations were taken to grant an NOC to the petitioner. So, however, he submits the resolution taken to withdraw an NOC has been recorded.
Yes, my lord.
He please be allowed to bring the entire proceeding book concerning the grant of NOC and also the cancellation before this court next date, just after 1 week. Let's see.
Yes.
Obliged. The Darbars can't function this way. If they are having some authority,
Right.
they can't say we don't have that part of the record.
There must be, my lord.
It's not possible.
The last one.
Yes.
This is a
Headman matter.
Is it Mafla matter?
my lord. They're supposed to file some affidavit.
Where? Number 5.
Yes, Lord.
You got a copy?
We have received a copy, my lord. Well, as per the last order, that was on 13/8.
1 second.
Because the question regarding the applicability of the customs to the elections of the headman has arisen, and they were accordingly asked to file an affidavit. Well, even before the council, we had taken note of this because we will come to the order at page 46.
Yes.
My lord, second last paragraph.
There is one number 1.
Page 46, my lord. The crux of the matter
Yes.
lies with regards to the condition or criteria for the qualifications of the candidates for the post of headman. The election committee, we believe, was constituted by the Lingdo and his executive Darbar, and therefore it is implied that the guidelines imposed by the election committee are framed and approved by the executive Darbar. For a clear picture, we will look into the guidelines, specifically clause 4 of the eligibility criteria, which bars the applicant from filing his candidature for the post of headman. In our opinion, this clause 4 should form part and parcel of the Adong Hima Part 1, which outlines the general duties and responsibilities of the Rang Bashnong. But on perusal of the Adong, we find no such criteria, and nowhere does it disqualify a resident from contesting based on legal litigation against the Hima. We have also gone through the notices as well as the resolution of removal, and we fail to come across any condition barring the appellant who is the removed headman Rang Bashnong. We consider the resolution to remove the appellant is a punitive exercise, and as such the matter ends there and cannot be taken to be perpetuity in nature. Because their contention, my lord, is that there is an Adong Shnong which says that any person who files a case against the Hima will be debarred from contesting the elections.
The Adong Shnong, that is
They were supposed to bring that. What is that Adong Shnong?
this is the one, correct?
Yes, ma'am. My lord, My lord, as per the last order, we are supposed to file some materials. My lord, it's ready, my lord. If we're allowed to file it within a day, at this point. It's already ready.
With the adong stong, everything enclosed.
Everything is there.
Come tomorrow, my lord.
That was it. That will be my lord.
Mr. Charnath, when the matter is taken up, Mr. Charnath, let us counsel for respondent number. Number?
6. Number 4.
Number 4. Submit the affidavit to bring on added materials is ready. It will be filed in the course of the day. Unless this matter day after tomorrow. Because you see, we have to get a larger picture also. Whether we can just disqualify a person. You see it issued.
Well, the other aspect, my lord, is someone who has just been disqualified, my lord. He is removed from the post. Can he be allowed to participate again? He comes back, my lord, then again remove him, again election.
Why remove him when he comes back? He comes back
because the act that is in past, my lord, that says that if he acts against the interest of him, he can be removed. So there is a.
But unless the act says so.
But power of removal is there, my lord.
We'll examine that. That's interesting.
Item number 4.
Yes. But kindly, Mr. Nath, you give copies to all the respondents.
Please, Lordship.
Yes, start. Ready the matter today?
Lordship, the then Advocate General is having some personal difficulties.
The
Lordship.
point is very short.
Yes, Lordship, but.
It's item number
4, Lord.
4.
Kindly list this matter after 2 weeks.
No objections.
Where's your senior?
He's on legs at the moment, my lord.
We'll post it for. Is for admission hearing correct today? We'll dispose of next date. You inform your respective arguing counsels on a joint request made by the parties. It's joint request.
Joint request.
Yes, list this matter after 2 weeks.
Much obliged.
Much obliged.
Next date, no further adjournment be taken.
Much obliged.
Well, the point is very short.
Item number 5.
This is the last order.
May I please, Your Lordship?
This is the last order.
Yes.
Your Lordship, we already filed the bullet points.
You filed them?
Well, it's from our end, it's ready. We've not filed it as yet. We'll file it by tomorrow, my lords. This is that matter which my lords had heard at length. I've just
forgotten now. I mean, this for filing of bullet points.
My lords, this has been too long. Would my lords, fix this matter next week? Then, my lords, we can just recapitulate whatever was argued, because our arguments had been advanced at length by both sides.
Who's appearing? Who's your?
Mr. Pandey had appeared, my lords.
Mr. K. Policy Counsel submits that as considerable times elapsed since the matter was last heard, he suggests that perhaps the matter be fixed as a final date for recapitulation and for filing a bullet point.
We'll take 5 minutes each, my lords. We can at least replace whatever was.
Okay, just
honestly, because, my lords, even I have forgotten what was argued.
Just after 1 week.
Obliged.
Okay.
Item number 6.
Please, Lordship, as per the last order, we have taken a press step to reissue the notice to all the private respondent. We have written an application to the post office and to clarify.
5, 6, 8, and 9.
Yes. There is
7 served.
7 served actually, but then yes, 7 served actually, but then somebody is appearing on the last occasion. This H Nong Pla was appearing for respondent number 7.
Who?
It's recorded Nong Pla.
Which date order?
It's date order 10/07/2025, my lord.
10
June 2025. 10/7/2025. Yes, appear for respondent number 7.
H. Nong Plo.
Yes.
Who's H. Nong Plo? Anyway.
She's appearing on behalf of
who's he?
Kelly Tap.
You know him?
Lord, yes.
He's from the same chamber with you.
She's appearing on behalf of Miss Kelly Tap, Your Lordship.
He's the same chamber with you.
She, Your Lordship.
He?
She.
Oh, she, sorry. Yes, often indicates that survivorship, that the AD cards on behalf of respondents 5, 6, 8 and 9 still awaited. This after 2 weeks, petitioner is permitted to obtain status of service in the meanwhile. Will file affidavit?
Yes, Your Lordship.
You already filed?
Yes, Your Lordship.
Already filed?
17th of June, we have already filed, Your
Already
Lordship.
filed, okay. Yes.
7.
Much less, Lordship.
Yes.
May it please Your Lordship. Your Lordship, I'm praying for 2 weeks' time to file an affidavit in this matter.
This matter, isn't it dead? The main bit is gone.
Yes, Your Lordship.
But can any fact be ascertained on the ground
Lordship,
with regard to any violation?
Yes, Your Lordship. In spite of the stay orders passed by this Honourable Court and the respondent being aware of it, Your Lordship, they have entered the property and raised the grounds and removed whatever was standing. Obliged, Your Lordship.
As paid for the 2 weeks time not for affidavit by the respondent.
Obliged, Your Lordship.
But I think this was his winner. He's not there anymore, Deputy Commissioner. It was during
No,
his
Your
time.
Lordship, is he's been transferred, Your
Oh,
Lordship.
during his
This
time.
particular
During his time, Your Lordship. And in fact, the affidavit that he has filed also reveals this.
7.
Obliged,
8.
Lordship.
Do we have filed or is under let this matter come up for hearing, my lord?
What remains in the matter, Mr.
My lord, will require some hearing, my lord. Let it come up for hearing at least, my lord.
Your Lordship, nothing survives in this case, Your Lordship. In fact, whatever they have written in the rejoinder,
I
it's a
got a
fresh.
guarantee from you, Mr. Sundram, that every festival that this, who's this?
We have already filed
your respondent number?
Number 4, Your Lordship.
He's the
we are the Raj Malyam, the chairman of the Raj Malyam, the Dorba.
We have filed a rejoinder, my lord. Let
okay, we'll just hear it.
Yes,
then let it come for hearing after 3 weeks.
There's nothing survive in this case. I mean, whatever they have raised, it's a fresh cause of action.
My lord, that can be seen, my lord, during hearing, my lord. Obliged.
9.
Received.
My lord, no. Your Lordships, can you see the order dated 25/7?
Where's who's appearing for UGC?
Your Lordship, I'm appearing for
Then what
UGC,
happened?
respondent number 3. Your Lordship, I thought the other counsels will be there with me. Your Lordship, Your Lordship, I've just been newly engaged, so I've just received the files to Lordship. I'll take further instructions and I will
What
do it
instructions? You see
accordingly.
what's happened here?
Yes, Your Lordship, I've gone through the
You've gone
orders.
through the file.
Yes,
You
Your
realize what's
Lordship.
happening.
Yes, Your Lordship. So if I can be so Your Lordship, if I can just be granted few days, I'll be getting instructions and I'll be providing the court instructions.
A week's time may be given, my lord. A week's time may be given.
Yes, Your Lordship.
Your Lordship is here on the.
See, the thing is that if this you see you've issued it, then where has it gone? It's lost in cyberspace somewhere.
No, Your Lordship.
Then, if a person's qualified the net exam, she's waiting 1 year now.
More than 1 year.
Waiting for a certificate to be issued. How will she apply for a teaching post if she doesn't have a certificate?
Yes, Your Lordship, I understand.
And as per your affidavit, you say you already issued.
Your Lordship, I'll just take instructions as to where it has come to. If I can be granted some time, Your Lordship.
Yeah, S. Lang stay.
Yes, Your Lordship.
Ms. S. Lang stay, who's present behalf of number 3.
Yes, Your Lordship.
Today's praise that without just 1 week's time to obtain specific instructions. Stop. It is to be noted that the matter concerns the grant of an NET certificate, which the respondent number 3 has stated an affidavit that's already been issued. But however, as per the petitioner, the same is yet to be received.
Not.
It is up to 1 week. You please instruction.
Much obliged.
It's a small matter.
Yes, Your Lordship.
Obliged.
Item number 10.
Please, Your Lordship, I'm praying for some more time, Lordship, to file our affidavit.
What about number 6?
The last date, Mr. David appeared.
I will ask those NGOs to appear personally and see what is their stake in the matter.
Good.
After some time, where is Mr. Deb?
We'll just try and
where that councils appearing just now? Run away.
Maybe taken up after a while. We'll just try to see where he is.
Hearing. Hearing item 13.
You should notice.
Yes, sir.
We'll dismiss this matter.
My lord.
You received it also. They have received this notice. Huh? Only over a month. The registry had issued notice to had issued a letter to the petitioner on 25th July 2025, informing directing him to take necessary steps to ensure representation before the date listing before the next date of listing, which was 21/8/2025. Today also there is no representation on behalf of the petitioner. If there is no representation next date, the matter shall stand dismissed.
15.
Yes, Mr. Sen. Yes.
In fact, Your Worship will see the last order. This Ilyas Maruli.
Last order, what did you say?
Last order. In fact, Worship has heard the entire matter and give some clarification.
Your Lordship, I was trying to contact the petitioner, but I couldn't due to some network problem. So please keep it alive only for 1 week. After that, we'll decide whether to continue with the matter or withdraw it. There will be no further prayer for extension of time. 1 week, Your Lordship.
Network problem?
Yes, problem because the place where he is staying, there is very difficult to connect. But I will do some other thing. Somehow I'll contact him and get his instruction. 1 week, Your Lordship.
Mr. D.K. Datta, the counsel petitioner, prays that he be allowed to prays that the matter is opportunity to enable him to obtain specific and last instructions.
Yes.
From the petitioner as to whether to continue the matter or withdraw the same.
Yes, sir.
A same law objected to by Mr. S.N. Just after 1 week.
18.
Yes.
Please, Lordship, DSJ is on legs, Lordship.
You're already at the end of the board.
Your Lordship, NVT is also, Your Lordship, in this case, Your Lordship, based on the mitigating circumstances, Your Lordship, the order of the...
Okay, you assess the court, how the court get around this prescription of the minimum imprisonment prescribed.
Your Lordship,
on what grounds?
Your Lordship, on...
The court's willing to help you.
Yes,
but you have to show the way the court can help you.
Your Lordship, on... That is the only ground, Lordship. She has done 70 years. Now, even if the order will be reverted...
Suppose a dreaded criminal 70 years commits some crime, just go 70 years, we'll let them go scot-free.
Your Lordship, she is, as her affidavit also, she is suffering from old age sickness, Your Lordship. And she is a woman, Your Lordship. So, on the sympathetic grounds...
A woman can't commit crime.
She can, Your Lordship. But on the mitigating circumstances, as an exceptional case, Your Lordship. Otherwise, a woman of 70 years now, she'll be in...
How old is she now?
70, Your Lordship. She's suffering from diabetes and other hypertensions and BP issues also there. As of now, she's on the bed rest only. She does...
Minimum term will be 1 year, correct?
6 months, Your Lordship.
6 months, only.
Yes. Your Lordship, as such, Your Lordship. And there is a delay of 7 months also. That's why I'm praying only as a this court under 226 as an exceptional case, not to set as a precedent, Your Lordship. That may be recorded on a humanitarian grounds, Your Lordship.
That's the only ground?
That's the only ground, Your Lordship, right now. The other judgments, as Your Lordship is aware, many times I have placed. Some judgments are supporting me. Your Lordship, fairly, I'm submitting that there is no judgments of this Honorable Supreme Court. Otherwise, I would have placed. I have searched thoroughly.
There won't be also. Because if the law demands that, then it has to be.
I have searched thoroughly, Your Lordship. That's why I'm relying on the High Court.
Then we close it.
Lordship, I'm praying, Lordship, if the matter can come up tomorrow and...
Okay, this is tomorrow.
Okay, Lordship. Your Lordship.
Now the court's willing to help you, only that you show the way.
19.
Yes.
Given the copy.
Yes, Brother.
Yes, may I please, Your Lordship. Your Lordship, this Group D post has not been abolished. There is no order or notification for abolition of the Group D post. The Group D post has been upgraded, Your Lordship, as Group C and redesignated as with a common designation as multi-staffing staff.
Where are you reading from?
I'm not reading, just I have some points, but this I quoted from their affidavit.
Just refresh the facts a bit.
The fact is, Your Lordship, we filed a writ petition.
Yes.
In 2023, the number is WPC 103 for regularization of service of the laborer with temporary status, and the Honorable High Court passed an order dated 3/5/2023 in the writ petition 103.
Yes.
That is in page 21, Your Lordship, in page 21 of the petition.
Yes.
So the operative
you are praying against this scheme. It's called scheme of.
According to the scheme.
Yes, as per the scheme.
There are two parts in the scheme. One is temporary status, and the other part is regularization. 3 years after getting temporary status. So temporary status they have granted to us, but now this regularization is.
Now you want regularization against those vacant Group D posts.
Actually, Group D is redesignated.
No, I mean what you prayed earlier on was.
Yes, vacant. Yeah.
You regularize me against a vacant Group D post.
Yes,
correct?
yes.
If you are eligible as per the scheme.
Yes, we are eligible. Yeah.
Okay. Then what happened?
Then what happened? They issued a letter that is at page 25. Letter
in the affidavit or in your writ petition?
In writ petition, Your Lordship.
What did he say? Yes.
They say that they are required to take sanction this and that, and this is quite outside of the scheme, Your Lordship. That is not at all required, because the university is an autonomous body. It has granted temporary status.
Yes.
At its own. So regularization also has to be granted at its own. So there is no question of taking permission, sanction or whatsoever. And after that, UGC also, they have filed affidavit, NEHU has filed affidavit, and now
they reply that however no reply has been received. Correct?
Yes, sir.
Therefore, unless a directive received the UGC, so and so, okay. Then what happened after that?
After that, we filed this writ petition, Your Lordship,
challenging
that order, that letter of the university issued on 12/9/2023. And the contention of the university is, respondent university is that Group D post.
Where is that?
Abolished. At the same time, they say it is upgraded as Group C and redesignated as.
Where is that in the affidavit?
It is in their affidavit at page 4, para 8. I'll read it. Yes. Subpara, the respondent university does not have any malified interest whatsoever to misinterpret the recommendation of 6th Pay Commission report with regard to Group D employees. It is factually established that the implementation of 6th Pay Commission, the elsewhere Group D posts have been redesignated as Group C
with common designation as multitasking staff. That is what they say.
What is the pay band of Group D posts?
It is pay band is pay 18.
No, the pay band of Group D posts, and if the redesignated as Group C, is there a difference in pay band?
Yes, there is, Your Lordship. There is. There's for which the recruitment have been initially and in total with the approval of authorities. So and so the rupees 1800 in the pay band of PB1 plus.
What is PB1 plus?
This I have no idea, Your Lordship. This
what's PB1 plus?
This is from their affidavit. Pay band.
Pay band, yes, 1 plus.
What is the amount of payment?
I want to see the difference between Group C and Group D.
Well, it's higher. It is this much I can say, my lord. Exactly, I want to be payment one.
No, but is there a difference?
Yes, difference. Is it higher, man?
Higher. How much higher? Marginally higher or substantially higher?
Substantially higher.
Okay.
So
continue. Then?
So now we pray for the grant of.
Are you qualified to hold a Group C post?
Yes, Your Lordship, we are qualified because as per the scheme, as per the order, this memorandum.
Where is that? Lecture 3 and 4. Oh, yes.
So the scheme is silent about the qualification, Your Lordship. Actually, the minimum qualification is
page 13, Your Lordship.
Page 13 of your?
Page 13 of my
affidavit.
Pass. 10 pass. That's C, 4C.
Minimum qualification is 10 pass.
Yes. So, Mr. Sen, you can consider the regulation against
the problem here. The whole problem, Lordship, will appreciate one thing, my lord. The first thing is, my lord, that 1993, that scheme, that Government of India has floated a scheme, Personnel Department, floated a scheme. That was meant, my lord, purely for the central departments, not for the university. But subsequently, my lord, it is UGC will have to play a role. UGC has extended that. In 98, they have extended that you will have to confer the temporary status, provided they had completed on the cutoff date 240 days. And then other thing comes, my lord. Once they are conferred with the temporary status after completion of 2 years as a temporary status employee, then they are entitled for regularization against Group D post. So admittedly, this writ petitioner, my lord, at the intervention of the court, granted this temporary status. By the time it was granted, my lord, following
the earlier order.
Yes. Following the 6th Pay Commission, what happened? Group D post has been redesignated as Group C post. Now it's a higher pay scale, number one. Even the qualifications are different. And my lord, we do not have the authority unless it comes.
One thing, Mr. I want to know.
Yes.
Suppose now you temporarily appointed them, right?
Right.
Now, under the scheme that they are casual employees.
Lordship.
Against Group D post. Now Group D post has gone. Will it be considered temporary appointments against Group C post?
Cannot be.
What will be the situation then?
Situation will be, my lord, here. That's why I'll just coming to it. We sought a clarification from the UGC. We have written to the Ministry of Personnel.
They have made party.
UGC is a party.
Yes.
In fact, in last occasion,
where's that?
We have served a copy.
MSS Langste.
So unless if a clarification comes from that, yes, you can do it by relaxing the qualification. Many will not have the qualification.
They have filed affidavit.
Yes, they have filed affidavit, Your Lordship.
They have filed affidavit.
Are you standing counsel or just engage case to case basis?
Sir, I've just been appointed standing counsel.
Standing counsel.
Yes, Your Lordship.
How many years you practiced?
Your Lordship, 3 years.
3 years. In which court? This.
Your Lordship, I had been enrolled in 2021, but I felt very ill for 2 years, coach. I couldn't even walk. Then I joined practice.
So you are not practicing any other court, only in Shillong only.
Your Lordship, I go to work 8 times.
You're standing counsel, so you can accept notice in this matter.
We have started a copy. My lord, what I suggest, my lord, in this case, instead of my lord keeping it pending, my lord, a clarification need to come for you. You see, we have written a letter, my lord, that is in my affidavit, your lordships, at page. My lord,
you're aware of this matter?
Page 8, Annex 1 of my affidavit. Now, this is addressed to the Ministry of Personnel, but with a copy to the UGC, because UGC will have to respond, my lord. If I can read, my lord.
Yes.
Lord, 6 to 23. This is addressed to the Ministry of Personnel Public Grievance. Clarification on regularization of temporary status schedule labor. With reference to the subject cited above, this is to inform you that the Northeastern Hill University President is having 12 casual workers who has been conferred with temporary status, whose details and particulars are enclosed herewith. It may be stated that the casual workers were conferred with temporary status by order dated such and such respectively. The university has taken up the exercise to consider the granting temporary in pursuant to the direction contained in order dated such and passed by the Honorable High Court of Meghalaya, such and such a copy of the High Court order, that as per the scheme, casual labor workers scheme government 1990, such casual labor employees conferred with temporary status would be eligible for regularization again group D post. However, following 6th February, all D post has been upgraded to group space. The office memorandum dated such and such issued by the government of Ministry Personnel Department such and such, and the regularization of the casual laborer with temporary status had advised to send the cases of all remaining casual laborers temporary status who were on the rolls of the ministry's department on such and yet could not be regularized may be forwarded latest by such and such for the department's consideration examination. In this connection, it may be stated that at the relevant point of time there were no temporary status casual workers in the university, as the university was not in a position to send such cases. Therefore, since the conferment of temporary status as referred to herein above is a new development on the basis of the direction of the matter is forwarded herewith. We copy to, my lord, university grant commissions. It is the university, it's not personnel. I understand, my lord, they are concerned mainly with central government, not with the university. It is the UGC, my lord. Lordship can, my lord, dispose of the matter.
What about this April 2011 letter, Next 3?
My lord?
See, you're requested to adopt the same.
Lordship.
With the approval of competent authority. Now UGC has extended the scheme. This is from the
Ministry of
this UGC itself. This is 2011 letter.
My lord.
See, I'm directed and close a copy of the model recruitment rules for Group C post and pay band 1. So you're requested to adopt the same with the approval of the competent authority. What's the competent authority?
You were requested to adopt the same the approval of the competent authority as per the state. If the university has already advised the non-teachable, this will be the EC, my lord.
And EC has adopted them.
EC is adopted. Now,
what more endorsement do you need from the central government?
This is regarding, my lord, the recruitment and qualification, my lord, by a rule to be provided for the Group C post. Now, Group D post, my lord, under the scheme, it is only the Group D post. Now, this has been redesignated as Group C, my lord, higher post. Qualifications are different. Well, there is a higher qualification.
You see, how do you reconcile with this? But if it is, when you recruited,
but they were conferred with in 2018 and 20 temporary status, though with retrospective effect. My lord, there is a single cut-off date, 93. So all has to be
93. 93.
See, the thing is that
1st September
2010, the Group D post done away with.
Done away with.
Then?
Done away with.
And 2011, they said you adopt the scheme formulated as per, to the model recruitment rules to Group C post, because they can't say Group D, but Group D doesn't exist anymore. That
Group D do not exist, my lord. I am admitting.
Then 2011 doesn't exist anymore.
Do not exist.
Then,
so this is the problem.
So what is the problem?
Under the scheme, my lord, they are entitled for regularization under Group D.
No. Now you see, if all posts under Group D posts are considered to be Group C posts now. That means they'll be considered to be temporary appointing as Group C posts. That's the reason.
That here will be the
Yes,
problem.
Lord.
Unless that clarification, that's why, my lord, we sought clarification from the UGC. My humble submission, my lord, without UGC.
What clarification do you need? It's common sense.
That's why.
Firstly, you have a mandate from UGC that that with the approval of competent authority, you apply this scheme. And that's 2011.
No, what my
correct? Now you see, Executive Council has applied the scheme of model recruitment rules for the university as per the central government model recruitment scheme. Right? Number one. Number two. Now there's no more Group D posts.
No more.
Now, how can it serve just like that? Not against any, temporarily against what post?
My lord, they are the casual workers, my lord.
No, they are
not against
also, not casual workers.
No, my lord, they have been granted temporary status, my lord, without any post. There is no sanction. It's not against.
Then they're working.
That is not against the sanction, because that is what the scheme contemplates. It's not talking. They are talking about regularization when the Group D sanction post is available.
Now they're working against what post?
Not against a post.
Temporary status. Casual laborer with temporary
How much
status.
you paid now? Daily wage.
They get the minimum
That
basic.
is pro rata, yes, minimum pay.
Minimum of the regular post.
Regular post. 30 years.
It speaks about Group D post, my lord. I admit, since 2010 it has been abolished. Now redesignated as Group C, my lord. Rule has to be brought in place. Now our only impediment, my lord, if it is clarified by the UGC, my lord, what your lordship, my humble submission will be, lordship can direct the UGC, my lord, to take a call on our letter. But they have not taken a call. If they take a call and they say if there are Group C posts are available, and my lord, then the question will obviously come, my lord, relaxation of education and
Now you see this in the affidavit. Now it runs counter to what they're saying in that 2011 letter. They're saying that Northeast Universities have statutory organization, certain neighborhood employees are not covered in said scheme.
Your lordship, in this regard, a long time back, this scheme came in 1991.
Now the scheme, okay. One more question for you. Was this scheme one-time measure or is
one time
in perpetuity?
Supreme Court has declared one time. This is a one time.
Then
on the cut-off date, it has to come. This is a one-time thing. But that decision, if you lordship, Supreme Court, this issue went before the Supreme Court. Someone they say this is, remember, this is a one-time scheme.
So at that point of time, when a one-time scheme came out, there were no temporary workers, according to you.
Yeah, my lord. What happened, your lordships? Many we found they completed 240 days. We granted. This was extended only in 98 by the UGC. Though it is 93, my lord, to university it was extended in 98. So we found some clearly completes 240 days.
So you gave
some
them the
cases,
benefit of that one time.
yes, do we have given. Now some, what happened, your lordship? They were somewhere short, my lord, 1 day, 2 days. Some of them they approached this court, and somehow, my lord, court intervened at a later stage. That's why the delay, my lord. And that's what we have informed the ministry also, my lord, at the intervention of the court. So we ignored the technicalities, my lord, conferred them. Now we have facing this situation. So let a clarification come from UGC, my lord. We have no problem. But there will be the question of relaxation, my lord. There are 12.
That doesn't apply.
Because still date, my lord, I have the instruction, my lord. We have not received anything from UGC.
Your lordship, UGC had already instructed to regularize. This is a letter issued in 1996.
96.
Scheme came in 1991. After 5 years, they issued.
Started after abolition of Group D posts. Had this Group D posts there?
From 2010, Mr. Datta. 2010, Group D posts were abolished. Now your people are working against what posts?
They're casual worker.
Just floating around.
With temporary status.
No post, man.
And they're entitled for regularization according to the scheme. Yeah, your lordship.
Where will entitlement come from? That's the only thing.
Yeah.
Can't leave him hanging also. Yes, this Dr. Pooja Agarwal, are you in contact with her?
Yes, Your Lordship.
Why she's not appearing today?
Your Lordship, she's not even in the station, Your Lordship. She's outside.
Doesn't matter.
Your Lordship,
she appears virtually.
Yes, Your Lordship.
And the scheme has to be implemented in toto, your lordship, not in piecemeal. Yeah, first give conferment, then stop this regularization. It is a part of the same scheme.
Yes,
let a clarification come from UGC. Things will rest.
The S and Leonard Council for the Respondent University submits that the only impediment that exists is the clarification from the UGC as to the status of service of the petitioners.
For regularization?
And as yes, as to the entitlement to regularization as per the scheme, under the scheme. He further submits that this is in importance in view of the fact that Group D posts have since been abolished. However, the standing counsel who had appeared, Dr. P. Agarwal, is not present today and is represented by MS S. Langste, who, however, is not in possession of any instructions on this aspect. In the interest of justice, this is a matter after 2 weeks. It's expected next date that the UGC come up with specific instructions.
They had already.
So let them.
Yes, in their affidavit that
they say that will apply. Yes.
The employees working under NEHU are not covered by the said scheme.
Call the second call.
Okay.
Item number 10.
Yes, where's your...
Lordship, I apologize, Lordship. Inadvertently, we missed out the matter from the list. I was required to file an affidavit.
On the road, a cup of tea in your hand.
No, Lordship. I was in the other court. We did not miss it and put it in the list. I am very sorry, Lordship. I missed out from the list.
We'll ask for personal appearance of your president.
Kindly give me 2 weeks, Lordship. I'll file my affidavit. I have already.
We want to know also what is the role? What is the interest? What's your interest?
I have no interest, Lordship. What had happened is.
You have pecuniary interest or you have what interest?
And I'm not the only NGO who has filed the FIR also. There are various FIRs.
Then where's the affidavit?
I'm just requiring 2 weeks, praying for 2 weeks.
Dr. Mosika, when you file an affidavit?
Somewhat 2 weeks time.
We had just lodged a complaint to the district council that they
We want to know.
Lordship,
We want to if the reason given for cancellation is because of your complaint. You want to know what is the complaint and what's it about?
Lordship.
You annexed your FIR everything.
Lordship, yes. We had sent a legal notice, so I'll bring on record all of that, Lordship.
Yes.
2 weeks time, Lordship.
As prayed for the 2 weeks time granted to respondents. 1 to 5 represented by Dr. M. Mosika also, and for 6 represented by Mr. S. Deb.
Was the interim order still further orders?
Much obliged.
21.
May I please, Your Lordship?
My Lord, the state has to bring instruction, my Lord. State has to bring instruction with regard to the decision which is pending before the Commissioner and Secretary, my Lord, regarding the financial
revision of pay as per the 5th Pay Commission with regard to the employees of the corporation, Your Lordship. We have not received any instructions as yet, Lordship. We have reminded them though.
What representation you have filed?
My Lord, we have filed representation before the Commissioner Secretary, my Lord,
Where is it?
MTC, my Lord. My Lord, page 44, my Lord, annexure 5, page 44, my Lord. To the Commissioner and Secretary, Transport Department, Government of Meghalaya, Shillong, my Lord.
It was in 20.
Are you working under the corporation or working under the transport department?
My Lord, we are working under the corporation, my Lord.
Then?
My Lord, the corporation is under the state of Meghalaya, this department, transport department, my Lord. We write 2 representation one before the director, my Lord, MTC, and one before the Commissioner and Secretary, because the state in the financial burden is always on the state, my Lord. The state, the salaries and other things.
For 5th Pay Commission.
Yes, my Lord. The benefits.
They have already
that's already been implemented.
from 2019 to
my Lord, only
it has been
2
effective,
years,
Your Lordship.
my Lord. The only grievance before this honorable court is, my Lord.
Yes.
The 2 years they have deducted, my Lord. They implemented not as per the recommendation, my Lord.
That
the
was
state has implemented in 2017. We have implemented in 2019, consistent with our financial position. They are aggrieved with that. They want us to be at par with the state and implement it with effect from 2017.
But with regard to other employees, is from 2017 also
No.
corporation?
No.
State government employees only from 2017.
We are a corporation.
But the corporation is not at par with
My
the
lord,
state government
my lord,
employees.
if the corporation, my lord, the pay structure, everything, my lord, is at par with the state employees.
Well and good.
The finance commission prior to fifth pay commission, my lord, fourth and third also, that exactly the MTC were implemented as per the recommendation of the commission, my lord. So all of a sudden in fifth pay recommendation, they have implemented from 1/1/2019, my lord, not from the recommendation date, my
So
lord.
when did the resolution when was
The resolution, my lord,
was taken in 2018.
Yes, my lord. MTC, my lord.
Was taken when?
2018 and again in
2018 to make it with effect from
1/1/19, my lord.
Then you have no case.
My lord, no, my lord, the benefit which would occur, my lord, from the commission, my lord, is once in a decade, my lord. It's a violation of Article 14, my lord. Discrimination, my lord. Discriminated, my lord.
They are a corporate body.
Yes, my lord.
Correct.
Yes.
They have their own
Board of directors.
Yes,
also.
board of directors. They have their own. The employees are not state government employees.
Yes, my lord. Yes, my lord. They are
You must remember
corporation.
that. If they are not employees of state government, nor has state government has any role in their appointment or in their termination.
By the
the
transport, my lord.
And so, if they take a resolution that will adopt the pay commission, which has been the recommendations of the pay commission given by the state government, maybe 2017, 2019, they'll apply in 2019.
My lord.
Suppose, I'll give an example.
Yes, ma'am.
Suppose you have in the department, you know, this ACPS, right? They have those schemes.
Yes,
right?
yes, ma'am.
Assured career progression scheme.
Progression
right?
scheme, my lord.
To avoid stagnation. Now, suppose in MTDC, there's not a case recently. They implemented the scheme, state government implemented the scheme from 2011, suppose.
Yes,
Correct?
ma'am. Yes, ma'am.
Now, MTDC, they see the scheme, they have also employees are stagnant in one post. It's like suppose it gives you a final assured upgradation of maybe after 10 years or 12 years. Now they adopted in 2015. We can't say that, you know, that now, since the state adopted in 2011, that employee who was appointed in 2011 will be entitled in 2021. Right?
Yes, ma'am.
On completion of 10 years. We can't say that. Because if the MTDC adopted in 15, that means it's entitled in 25.
My lord,
it's like that 10 years.
Only limited issue, my lord, herein, my lord.
It's not limited.
My lord, kindly, my lord, allow, my lord, since the decision is yet to pending before the commissioner secretary to the state regarding the release of funds, my lord.
Your prior representation, it's not a question of release of funds, it's a question of applicability of the recommendations.
Because, my lord, what they have passed in the resolution, my lord, because of the financial hardship, they could not implement from 1/1/2017, subject to the release of the funds from the state. So, my lord,
Subject
if state
availability
of funds, my lord, yes, my lord. If state release release the fund, then MTC can easily, my lord, disburse.
The board have already taken the decision.
My lord, only question, my lord, here is, my lord, in absence of any rules, whether MTC, the corporation, can, my lord, pass a resolution whereby they can change the cut-off date, my lord. That is the only, my lord, only things to consider, my lord. My lord, there is no rules with regard to that, my lord. No rule, only a resolution, my lord, which is pick and choose, my lord, whereby it's clear case of, my lord, discrimination, my lord, being discriminated.
Suppose they never adopted the fifth pay commission, what will happen?
My lord, that is
a situation where, okay, fine,
yes,
the recommendations are there, the corporation never adopted it.
No, my lord, under this, my lord,
do you have any vested right to say that they should adopt that recommendations and pay me the new scale?
My lord, as per, my lord, my lord, kindly fix this matter for full length hearing, my lord.
It's only full length hearing,
my lord,
right?
My lord, no, my lord, this is, my lord, for the bring the instruction, my lord. Well, kindly next week, my lord. or maybe my lord day after tomorrow, my lord. I'll bring judgments, my lord.
Your Lordship, may kindly appreciate that the corporation employees are not employees of the state government, Your Lordship. And in view of that, Your Lordship, they are not entitled. They are not entitled to that, Your Lordship.
What rights?
They have no rights.
What rights have you been provoked with?
What my learned senior government AZ, my lord, double AZ
Senior government
submitting.
AG?
Yes, my lord. Still, my lord.
Giving a double designation.
My lord, still state cannot run away, my lord. State cannot run away from the liabilities, my lord, because ultimately the burden is in the shoulder of the state, my lord.
They have already released from 2019, Your Lordship. They have already released.
The only question remains here, my lord. Kindly look at the manner in which the resolution was passed, my lord. My lord, this scheme, my lord, this benefit comes after a decade, my lord, and it is very important for the employees.
When did we retire?
My lord, we are retired in different dates, my lord. Different dates, my lord.
Oh, how many petitions are here?
My lord, 22, my lord.
Okay.
22, my lord.
24 petitions.
Sorry, my lord. 24, my lord. Yes.
The case is very simple, Mr. Hassan.
Yes, my lord.
You are working under an autonomous corporation.
Yes, my lord.
They have to adopt any, suppose the state adopts, there's a fifth commission, recommendations of the state, then fine. The dates for them to choose, depending on the financial position.
My lord, that cannot be the, my lord, ground, my lord, financial burden, my lord. It's still, my lord, there's a thin line difference, my lord. I'll bring the judgment, my lord. I've done some research.
Once they adopt a scheme, should adopt it from the date the state adopted.
My lord, the commission, the state government has constituted the fifth pay commission under the constitution. They have done thorough research work on the condition of the employees, my lord. They have recommended, my lord. Then the said recommendation of the commission, my lord, were implemented by the state, and different other corporations also implemented, my lord, like, my lord, municipalities, my lord. And prior to fifth pay commission, fourth pay commission, third pay commission also, my lord, constituted and recommended, and the MTC has exactly on the same date without any change, my lord, they have implemented, and funds were released by the state, my lord, and employees were get benefited. But all of a sudden, when the fifth pay commission comes, my lord, they passed a resolution whereby they have changed the cutoff date only on the ground that financial burden, my lord. That financial burden also not incurred by the MTC, it's incurred by the state, my lord.
How can you expect directions from the court?
My lord.
What kind of directions you expect from the court?
My lord.
The court will
under 226, my lord. This court has enough power, my lord. This court has ample power to direct.
We look only at illegalities.
Yes, my lord.
We look only at your violation of your rights.
My lord, kindly fix it day after tomorrow.
Legal rights or fundamental rights.
I will argue, my lord, on the particular issue, my lord. On two aspects, my lord. Whether MTC can, my lord, by way of a resolution, and violation of Article 14 on discrimination and financial aspect, my lord.
Yes. Your Lordship may dispose of the matter today itself, Your Lordship,
no,
because
the corporation
has no.
I want to argue on this.
The corporation have got no right.
No, my lord, since the matter is actually last occasion prior to 2 dates, the matter was fixed for bring instruction with regard to the pending decision. So I was not prepared, my lord.
The board has taken a firm decision that 2019 onwards it will be effective, not from 2017, Your Lordship.
My lord, I am seeking only 1 day time, my lord.
Okay.
Wednesday will be a little difficult. Thursday, Your Lordship.
Thursday, division benches.
Okay.
Gets a bit crowded.
Monday.
Friday is not a good day. Okay, next Monday.
Monday, my lord. I'll argue, my lord.
Mr. S.K. Hassan, please the matter be adjourned, allow him to prepare the matter further. But you know where the parameters are.
I understand, my lord. I try to pursue, my lord.
If you can come with one decision, then there will be remark.
I'll try to, my lord. With regard to the financial aspect and regard to the discrimination part, my lord.
Okay.
My lord. Highly obliged.
Mr. Lordship, the last occasion, Your Lordship, I have instructed to bring the record on the regularization.
Where's the order? He said he's proceeded.
Your Lordship asked for the instruction from the client.
He was never regularized.
No, he has been regularized, but then he has somehow
lost the order.
Misplaced it. Yes, but in the office of with the office. This record is with the office, he said, and even the office were directed actually to produce that.
Apologies for the video being off. My camera is not working. My instructions are that the post was always permanent. The post of client as a client he was never required to be regularized.
He's already regular employee.
Yes. It's a departmental.
What are you asking for now here?
Now we are here.
There was no question of regularization. Then he was promoted as a section assistant.
Yes.
But later on it was found that there was no provision of promotion from client to section.
He's retired now.
Now I'm retired, Your Lordship. My Lordship, may I just place, Your Lordship, just before my Lordship.
No need to place. If you are regular, okay. Now that you're regular employee, no quarrel. Okay, number one.
Yes, number one. That is not
whether your promotion is regular or irregular.
Yes, that's why I'm.
If there's no promotional avenue,
yes.
You enjoy the scale of sectional assistant. How long?
9 years, Lordship.
Then fine. Then your pay will be fixed against your pay on that.
No, Lordship, may I just on the last occasion there was an order also to bring that because they are saying that my promotion was wrong. They are saying that on the basis of the draft office memorandum, draft memorandum. May I just submit, Your Lordship? They can counter after my submission. What I'm trying to, because half listening, I will not be able to.
Half listening meaning what?
Because when I'm making submission, he also at the same time.
Half listening only.
Like that, God will not be able to understand what I'm trying to speak. That's why I'm trying to make it. Now, on the last occasion, there was an order to bring the draft memo. The contention, the main case of the is that draft memo. They are saying that draft memo, number one. Now, even they have changed even their stand also. At the first earlier, they were saying that draft memo is not proper. Then at the time of, now they are trying to improve. At the time of argument, they are saying that it is not implemented. And thirdly, they said that the draft memo, they said, since it has been long year, since 16 years back. That's why they're saying that the draft memo is not able to produce, it is not available with the office. That's why I'm trying to draw the attention. This draft memo, the order, the page 8 of the annexure 1 of the affidavit in opposition, Lordship, where they have enclosed one particular letter. It was issued by the Chief Engineer, PWD, Building Meghalaya, Shillong. That letter was issued on dated 7 April 2021. It has very clearly mentioned that I will just read the operative part of the letter. With reference to subject about I am to return to the service book part 1 and part 2 in respect of Sri Mohindra G. Moman.
Page what?
Page 8, Lordship. Page 8 of the affidavit in opposition. Filed by my learned friend.
Okay.
Yes, Lordship. Now now that I am returning the service book part 1 and part 2 in respect of Sri Mohindra G. Moman, Pion, as the same incumbent was later promoted to the post of sectional assistant based only on the draft office memorandum number so and so dated 26/7/1999, which is not proper. Now this letter in the backside it is written that this signature said that Chief Engineer PWD Building Meghalaya. Now this number one, my question is, how can they deny that this letter is not available in the office? Because the officer, the chief engineer, before issuing this letter, he has gone to this letter.
Please listen, okay? Now this only come. Wait, just MSI, just wait. 1 second. Now you see. Now your whole promotion, try to understand like this. Okay, there were no avenues for promotion from peon, okay, to section assistant. Number 1. Number 2, some draft was made that's never finalized. So even if you're promoted on the basis of draft, that promotion is not proper. Now you come to your annexure 5. I saw just now. See, annexure 5 of your petition, page 23. Read paragraph 4.
Yes, paragraph.
Yes.
It may be mentioned that the promotion of Sri Mohindra G. Moman from the peon to the post of a sectional assistant departmental promotion had held on 4th April 2012. based on the office memorandum white number so and so, dated 26/7/1999, which is not improper oversight. This has come to know when moved for approval and service regularization of Sri Munindra Jimoman to the office of the Chief Engineer, Shillong. Reply white letter dated so and so, which this office is very regretted for the same. However, incumbent served as a sectional assistant in the same post in the office of the PWD subdivision William Nagar for 9 years and retired on 31/05/2021 respectively. In view of the above, I would like to request you kindly to accept and consider the case of the Sri Mohindra Jimoman service to take up.
Yes. So, what is the position? Everybody realize that you are irregularly promoted, correct? Yes. You enjoyed 9 years scale of section assistant. Okay. So, you enjoyed 9 years scale. They say, please consider to fix your pensionary benefit as per last scale drawn. But if you were improperly promoted, he holds any rules or any promotion, rules. So, you can't be given that scale. Your pension will be fixed against the last pay drawn as peon, regular post. Simple as that. So accept that.
Lordship,
you want me to dispose of now?
No, Lordship, there is a judgment also where I would like to just place it.
You have the judgment?
Yes, Lordship.
I'm yet to see a judgment that goes against that theory. Yeah.
This is the one. Yes. This one, 2012. This is here. I just like to take it to the page. It is I written the page 27, but para 76, Lordship. I think I have put it page number. I think
76.
Yes.
Para 76.
Yes, para 76. Because
it ends at para 43.
43.
Where's the assistant?
This is
which judgment you're citing?
This is let me just see. What did different? Yes, Lordship, I'm sorry, Lordship, because this is this one. Take out this one. Put it this one.
Yes. R76.
Then 76. Yes, Lordship.
Yes.
May I just see to your Lordship. The another reason for not granting any relief to the original petitioner is that there is not even a single share of material on record to show that the appellant, Dr. Gaur, even misrepresented any fact. He did not at any point, at any time, claim to have qualification which he did not have. Other facts were before the government, and if the state or its officers did not check up the eligibility criteria in the year 1990, why should the petitioner suffer for no fault of his? He now is at the verge of retirement.
Without troubling you any longer, this is a case of appointment, not promotion. Yes. Upon promotion are two separate things.
No, for the page 21, Lordship, para 21 is wrongly.
This case is there was a post, a person is appointed against that post. I feel like I'm holding a class, sometimes.
No, para 21
a person is appointed against that post. After serving for 20 years, they found out that his initial appointment, he was not eligible actually for the post. And so, just to balance equity, said fine. He was appointed, not his fault that he was not eligible. His application is accepted. He was appointed, and so he's retiring. Let him retire. That's it.
No, is mentioned in para 21 is wrongly promoted. This one.
Just see from para 2. He was promoted because there's scope for promotion, but initial appointment was wrong.
Yes.
Get it?
Yes.
See this one, para 2. The whole dispute is on the appointment of the appellant.
Yes.
Now you come to your para 76, the read just now. Now, in this case, approval is granted also for his promotion, okay? Another reason for granting relief to original petition is that it's not a single share on record should apparent ever misrepresented any facts. He didn't misrepresent. He did not at any time claim to have qualifications which he did not have. All the facts were before the government, and if the state officials did not check eligibility criteria in the year 1990, why should the petitioner suffer for no fault of his? Simple as that. Next judgment, which other one you want to show?
This 2008. Here this para 26, my lord.
Yes.
27. There is no reason. Therefore, why the respondent should now be permitted, after lapse of so many years, to refuse to treat the license of the petitioner as the regular permanent license, and to treat the same as the temporary license, to the serious prejudice to the petitioner, since inadvertence or irregularity, if any, in the matter of granting such license was the sole responsibility of the respondent. Since the poor lay with the respondent, the petitioner should not be made to suffer, or for such for of the respondent. Reference may be made in connection to the decision of the Supreme Court in case of
this judgment deals with what? What is it? A service matter?
This is not, of course, not a service matter.
What is it?
This is regarding the liquor license giving to the liquor.
So how can you draw analogy liquor license and service of the free?
Actually, because due to the power of the respondent, another one is lordship. Yes, this is another
liquor license and service. You won't get any other court to give so much indulgence. Yes.
Lordship, this para 17, my lord. This is
same thing when a candidate.
This also is not service, of course, but then.
Okay. Yes. Oh, where's? You can't fix your video. Yes. You give a copy to Mr. P.T. Sangma. This is 99 draft OM. Very good.
So that's why I'm all of this. Meghalaya Ministerial District Establishment Services. Now, under this category, Marital is D2E. So, section after doesn't come in under the rules at all. Ministerial District Establishment means and includes 2E matter. Means and includes all non-resident ministerial staff who are transferred to district office, subdivision office of the district, of whom the district head of the district and the appointee. Now, whenever we come to point 4, rule 4, composition of the service. The service shall comprise of the following categories of posts in the offices and branches ministerial category 1. Head assistant, supervisor assistant, division assistant, division assistant. Each of the category of post missions and rule 1 shall form an independent cadre, and members of one cadre shall be made for appointment to any other cadre.
Okay.
So, my section is
yes.
Firstly, these are bathrooms that never got implemented, and secondly, there was no provision, and still there is no provision. We are still considering him to be treated as officiating on an official basis for the period which he has served yesterday.
No, now he's retired. You retired.
Joseph.
Are you getting a pension now?
No, they have not.
Not in provisional pension.
Not getting, not provisional, so we are not getting.
When did you retire?
We retired on 21st. Retired on 21st May 2021.
Since 21 to retire, you not got pension till now?
Yes.
Madam, he was not completing the formalities. We have even put the documents on pause because he was insisting on being considered as an estate. Because of that, this was not done.
Lordship, I will try to advise this petitioner, make him understand.
Otherwise this case will be dismissed.
No, next time I will try to make him understand.
Come under misconception, and even is the fault of the, government who allowed officials so long, or making him understand that it's only a temporary officiating position and not a promotion. The memorandum, a draft memorandum dated 26/7/1999 has been produced by learned government advocate. The same reflects that there is no promotional post to sectional assistant from peon. But the respondents maintain that the substantive regular post to which the petitioner holds is only that of peon, and the fixation of pension will also be against the pay scale of peon and not officiating pay scale that he had enjoyed as sectional assistant. Next paragraph. In this, Mr. P. Sama prays well to obtain necessary instructions. This after 1 week.
Lordship.
Yes.
23.
Lordship.
23.
Please, Your Lordship, this is a matter where my husband had concealed some fact regarding his marital status and got a pension. Now, briefly what happened, Your Lordship. I got married to the private respondent number 8 herein.
Number 8 is here?
Yes, 8 is here. Then in the year 2007, a divorce was granted to the respondent number 8 against me. I was aggrieved by that divorce decree. I had to appeal before the High Court, and that divorce was set aside. That was in the year 2013. The order is at Annexure 4, page, Your Lordship, page 25, Lordship. So the High Court order is at, sorry, Lordship. The High Court order is at page 18, Lordship.
80?
180, Lordship. So the divorce decree was set aside. Now, one thing, Lordship, this order which set aside the divorce decree was after giving notice, giving opportunity to notice.
2007 divorce granted to you?
Yes.
By which court?
This is by
Additional DC.
Additional DC, Lordship.
Where's the order?
2006, Your Lordship.
2006, Lordship.
Okay.
Where's
the order?
The order, Lordship, the order, in fact, unfortunately, Lordship, that I don't have a copy of that. But the recent one is the one which is set aside is there in 2007.
Okay. The 2007 order, 23/7.
Now, the respondent number 8, despite due service of notice, did not appear at this proceeding.
Number 8 is Muni Devi, 1 Commissioner Rao is number 8. You're Muni Devi. And who's this Ramslok Yadav correspondent?
This I do not know, Lordship. Why was he made a respondent? But it was set aside, that one thing, that decree of divorce was set aside. Now, one thing, this judgment was passed by the High Court, was after, despite due receipt of notice. Now, the respondent number 8 did not appear in this matter, but due service of notice, this decision had arrived to set aside. Now, what's important, Lordship, after this decision, now there were maintenance cases.
He filed for divorce.
He filed for divorce.
It's allowed
allowed.
Then you
appeal in 2007, set aside.
Okay.
Now, since 2007 until recently, last year, I was still married to him. I'm still married to him. What had happened was that there was a maintenance case which is pending before the Judicial Magistrate, JMFC. That again, subsequently, there was an enhancement. I seek for enhancement of that maintenance amount. I was not happy with the amount. Now, in that enhancement case, what happened was that he had required to file an affidavit for assets and liability. Now, assets and liability he had mentioned as being divorce, and mentioned the name of another person as his wife. Now, that assets and liability, Your Lordship, is at page 39. Can you come to page 39, Lordship? Now, page 39. This is the affidavit which is submitted. Now, the date of separation at serial number 6, he has given this is the date. This is the order which has been set aside. Is 2006. Date of marriage he has mentioned somewhere else, and then he had mentioned the name of the wife on the next page, page 40. It's the name of someone else. Wife is Sabita Devi. Can you see it? This is at C, details of dependent family member. Number 1, the wife in bracket Sabita Devi. This is not me. Now, because of this, I had come before this court, challenging the pension, the pension that he has gone in pension, submitted this. These are the one which is their details in the pension. I have also approached the department where they have provided me the pension book. That is at page 16 actually.
Page
16, 16 actually.
You mean to say that after you had challenged the divorce, the decree of divorce, he never appeared at all in the court? Was he served properly?
Maintenance, his
No, was he served? Because when the decree was set aside, was he aware of the proceedings for this court at all?
He was aware. He was aware. Now, in the affidavit in opposition, they're claiming that they are aware in 2012. Was the first time they were aware of it. The central stand is that they are only aware of his status when I filed this instant writ petition. They were not aware throughout. The department, that is the stand of the department, the affidavit in opposition, and the claim of the respondent number 8 is that they were aware since 2012. So if they are aware in 2012, they should have gone and challenged the High Court order. But they have concealed that fact and submitted the decree which already been set aside. So there's two different stand taken here. So they have not only concealed the fact from the court, they have also concealed the fact from the department who had proceeded with his pension, in finalizing his pension. The affidavit
C17, kind of particulars, Sabita Devi wife.
Yes. Sabita Devi, yes.
What? Where is the marriage certificate to Sabita Devi?
Marriage certificate,
have you produced it? Number 8.
Central at, in fact, you include certain affidavit, not a marriage.
Very strange case. Where is it, Dr. Mozika? Which page? Nomination.
We've enclosed the documents because he has to, for entry in the service book, my lord, he has to give us a declaration form. That is at page 16 of my affidavit, my lord.
Yes. So he has given here in the next page nomination, name nominees, wife. A. What is this? Married by affidavit?
It says married on 20/12/2006 according to Hindu rites and rituals at my father's residence.
So if she's making this affidavit, she made affidavit in 2012. She's 20. No, this affidavit, this 12. This is dated 27/12/06. 6. Okay. Married on 2012. So 1 week after. And 20 years affidavits of the. Okay. So, Mr. from 2006, no relations with you any further. You don't know about his whereabouts also.
Whereabouts? Not living as husband and wife. The status is still husband and wife. There is no official. There's no. He had gone on pension recently, 2024. The list is
so
given.
Pension, he'll draw his pension, whatever it is.
Exactly, but
he's
again,
drawing his pension. After he dies, then maybe you'll have, if you know, you still.
Cause of action will arise then, my lord. Cause of action will arise if he dies, my lord.
Yes.
And the second aspect, my lord.
Why you want to stop his pension now? To punish him?
Because concealment of fact and before the court is saying, and what about the order passed by the High Court which set aside the
fine. The marriage stands resolved. Fine, that doesn't matter. Right, that means you'll continue to be the first wife.
Yes.
So your cause action arises after he's dead, then you will get, the benefits.
My lord, there will be legal complication because during the period when, even before the High Court set aside the divorce, my lord, he remarried, he entered into second marriage.
Bigamy.
What will happen to that, my lord? That's it.
Because in the affidavit itself, now the retirement.
Is he drawing pension now?
He's already done. He's already taken the benefits also.
Yes, we'll hear you, don't worry.
So, my lord, the remedy for him is to institute appropriate civil proceedings, my lord, for declaration of her status in view of the High Court order, divorce granted and set aside. In the meantime, the husband getting remarried, my lord, having a second wife. And that also too since 2006, my lord, we are in 25 now. So even C cannot be just ignored like that, my lord.
That stands that. I've already taken a stand that
we'll hear you.
I have not. I was not aware. Since 2007, there were maintenance cases which were pending. He had never ever submitted any documents before the court, petition or affidavit and all, to tell the court that I'm already remarried. It's only recently when he filed that affidavit.
He divorced from you?
No, not divorce, because it was set aside.
He didn't know about
the High Court order is ex parte order.
Ex parte order.
Due notice, service of notice. He was aware in 2012.
It was properly served on him that his file again, you file an appeal against the divorce decree.
It's already in the first line of the judgment itself.
Yes. Come to side. So you were aware about the High Court order?
No, Your Lordship. I was not aware.
Then were you served or not?
No, Your Lordship.
Then who received on your behalf?
We're not aware. Since I got posted from one state to another, I did not receive the notice.
And thought you happily divorced?
Yes, Your Lordship. And I remarried in the year after obtaining the divorce. I remarried to Sabita Das, Lordship. Thereafter, it was only in the year 2012 when I received a notice for maintenance, that an interim maintenance was granted to the petitioner.
You didn't file for review of the order?
For the?
Review of the first appeal of the order.
We are not aware, Your Lordship.
No, you didn't. 12 now. 12 is more than 13 years ago. You didn't file for review of the order.
No, Your Lordship.
Why?
Since I was posted different places, I instructed my counsel, but due to...
So you didn't take any steps, no? But you knew in 2012 that your decree for divorce has been dissolved.
Yes,
has been set aside.
And since I've already married, it was the petitioner, Your Lordship.
You already married, that's a different aspect, because within the period you got married, Because another thing, Dr. Moisika, within the period he remarried, the divorce was still valid.
Valid, yes, Your Lordship.
Only after he remarried, then the thing. So that means you can't hold him for bigamy also, because that court orders operating at that time. He was divorced, so he married. So sadly, his divorce thing got set aside. That's the thing. How do you deal such situations?
Because there are some cases, my lord.
Wait until he dies, this one.
Then fight.
Then fight, yes. We'll dispose of this matter, Mr. Marpan.
Lordship, in
the best remedy for the petitioner is to file a civil suit, my lord.
They can do whatever they want.
Whatever they want to do.
And with regards to the financial aspect, they have already filed a maintenance case, Your Lordship, and still pending, Your Lordship.
That we won't pass any observation. Only that now we are looking at the pleadings in this case itself. What is your prayer? To stop his pension?
To suspend or revoke the
pension order,
the voluntary retirement, that order of him going on voluntary retirement.
Voluntary retirement.
Just to, and then also to direct the respondent authority to conduct an investigation.
What investigation?
Because again, they were aware from the affidavit itself that they were aware now. When I filed this, right, throughout they were not aware that
they were only the person himself. Only the question will come when the nominee arises, if he's dead. If person still exists, he is a person who served. He'll get the pension. I may be wrong, but that's the correct. I think that's the correct interpretation. So, what do you propose to do?
At least an inquiry, Your Lordship.
Inquiry to what?
To all the
drop DP against him now.
Not
what
possible.
What gain out of that?
No, he wants to punish his Parambe.
So it's very apparent in the face of the court from their admission into.
Why do you grant divorce now? Take a one-time settlement and close the whole matter.
If they agree to, then it's up to them.
You agreeable to that?
I have to seek instruction, Your Lordship, in regards to that.
What's the point of continuing?
Let them file a divorce suit or something in the civil court.
Who will file?
Because as far as
I have not been living
with...
with...
mutual consent, finish, it gets over. Due to not knowing that my divorce had been set aside, filing again for mutual consent with them.
And also one thing, I've already gone through that affidavit. Now, they have stated in that affidavit, which was notarized much later, in 2011. Now, again, the validity of that document is also highly questionable.
We're not going there. We're just saying that, see, the only thing, the marriage took place in between after the divorce and before it was set aside. That's the only thing.
No, but again, from the affidavit which was notarized much later, 2011. Now, notarized 2011. Now, the divorce was set aside in 2007. Now, if you see the timeline. So,
but they came to know in 2012.
2012.
Then notarized 2011.
2011, but the divorce or the set aside happened in 2007.
They were not aware till 2012. So, you mean affidavit that I am divorced?
That is just a statement they've given. It's highly speculative.
Where are these people situated now?
He has shifted to, I think, Bihar.
And you?
I'm here in Chilla.
So no point mediation also. Yes.
Because I remember one of the cases, because these situations happen very frequently, divorce granted, for example, and then the husband is in a very rush to marry a second wife. Then in one of the decisions, the Supreme Court, High Court said that you cannot remarry after grant of divorce till the appellate to the limitation period for filing appeal. Because it happens many times that appeal is filed and there's reversed.
The divorce was granted on
17/5/2011.
2011.
I got married in December.
Your divorce granted on. By the
17/5/2006. I got married on 20th December 2006.
After limitation period.
7 years, 7 months, Your Lordship.
Yes, limitation period over.
Yes,
but that which is the claim in the affidavit. Now that affidavit was solemnized in 2011. In the affidavit itself, very clearly.
2006.
2006.
Solemnized.
2006, yeah, Dr. Notai.
2006.
27th, 12, 2006. That's why this court noted it earlier. Otherwise, Mr. Marpani withdraw, seek civil remedy.
Sure. Just give me
the
one
view of this court is that no purpose will be served by pursuing this. You know what order is going to come.
I have come here with one ground, Lordship, just to show
because
the
you have to take evidence also when they came to the knowledge.
Yes.
All this, you can't.
I understand. This court cannot do that, Lordship. But again, one thing is that they saying that they are aware of it in 2012 also. Where is that?
How is the court?
Exactly.
This court ascertain that.
That's also one thing.
Jurisdiction.
Exactly.
Make him stand there.
But going by the order.
Don't have original jurisdiction. I mean, we can't take evidence.
I understand.
Yes.
Going by the date of the order, how it was passed, and them having a knowledge in 2012. Now the retirement.
See, if a person's playing smart, so what can you do? Maybe he was aware. Maybe he consciously did not take part.
The petitioner also is nothing on record that after she got a High Court order, she communicated this order to the husband. There's nothing on record.
No, maybe he knew also, but he was already married, so he kept quiet. Why he complicate his own life? Right?
The thing is that order which I'm challenging, the voluntary retirement order, that is just last year, 2024. When I got that order, and later subsequently when he submitted that affidavit before the court, that's the suspicion when I had come before this court and I knew that he had concealed those things.
You don't know anything that he remarried? You had no idea?
No idea whatsoever. It's only after I got
even after details. You got order setting aside the decree of those, you didn't see, look, we're still husband and wife. You couldn't file for restitution of conjugal rights. Then you could have filed. You see,
was the petitioner who left me?
Abandoned marriage.
Abandoned marriage. No relief in this petition. I don't think. You fight after he dies. How old is he? That's why you don't kill him, of course. That's all. How old he did of birth?
6. He took VRS, so he's 53.
Only 53 now?
Yes. VRS.
Young chap. Yes, Mr. S. Marpan.
At least
after hearing some length, Mr. Marpan, please be allowed to obtain instructions from his client. Yes?
At least 1 week.
Respondent doesn't need instructions. Whether you withdraw or he will.
Then in that case, I will withdraw your Lordship. In that case, since we had just had a hearing, I don't want to again give submissions again. At least certain observation, whatever we have submitted, that may be reflected, Lordship.
Right. Mr. After hearing at some length, and after hearing the parties at length, Mr. Marpan prays that be allowed to withdraw the instant that application with ability to seek with liberty to seek civil remedy, as the matter involves questions disputed facts also. Stop. In brief, may be noted that the challenge was initially against the
VRS pension order dated 1874.
The voluntary retirement pension.
The voluntary retirement pension dated 18/7/2024, which of the respondent number 8. Stop.
I've given a list of dates.
Not necessary. Okay. Yes. Number 8. Stop. The other prayer was for direction to the respondents to conduct investigation into the pension application of the respondent number 8. Stop. Like the basis on which the challenge has been made is that the petitioner was initially married to the respondent number 8, and on 17/5/2006 the same stood dissolved by a decree passed in the divorce suit. Divorce suit
80
in a divorce suit, yes. Okay. Number 8
in bracket T.
8 with bracket T of 1996. It appears the Respondent A then submitted declaration forms and other testimonials declaring his marriage to one Sabita Kumari on 2012-2006. On this declaration, the name of next of kin in the pension documents submitted by the respondent number 8 was then accordingly changed to that of Srimati Sabita Devi. The petitioner, on coming to knowledge about the application for voluntary retirement, right?
Yes.
Had filed representation to the respondents and submitted a copy of judgment and order dated
23/7/2007,
passed in
RFA number
10 SH of 2006, which has set aside the decree of divorce dated 17/5/2006. Is to be noted herein that the said order was passed ex parte. Next, as the situation persisted, ex parte. In this backdrop, the writ petitioner had preferred the incident application. But however, upon the court observing that since the respondent number 8 is still alive and there is no legal requirement for holding of the penitentiary benefits to which he is legally entitled to, the counsel for the writ petitioner had made the above noted prayer. In consideration thereof, the matter stands closed for withdrawal, leaving the writ petitioner to seek alternate civil remedy. Matter stands disposed of.
24.
Ready, Mrs. Naitang?
Seeking for some accommodation, Your Lordship.
For accommodation?
2 weeks time we will give Your Lordship. It's listed for the first time in hearing, Your Lordship.
Yes. Which department is this?
She was a teacher in Don Bosco College, Tura, Your Lordship. Education Department.
You ready with the matter?
Lordship, today we're seeking for some accommodation, Lordship.
What to do, Mr. Snaitang? You chimmer don't like to do hearings. Only fresh cases only. We will reverse that. Should we have a day only for hearings, I think? At least 2 days in a week, no fresh matters, only hearing. Then we reconstitute the benches. What do you think?
In fact, there was a...
At least 1 day only a hearing day.
Oh, I thought she was talking about this.
No motions, no admissions, no orders. Then we will have also that the first 10 matters, no adjournments. Then that way, I think. But even then, I don't know. It's on Mr. Naitang. Due to personal difficulty, this matter after 1 week.